I was telling you the difference between child and juvenile. If you see definition of child as has been provided under section 2 subsection 12, a person who has not completed 18 years of age. Similarly, a juvenile means a child below the age of 18 years. If it is so, then for what purpose these two terms have been used in the Act? A child could be CCL who has alleged to have committed an offence as has been given under section 213, or a child in need of care and protection as has been given under section 240 of the Act. Both are considered as juvenile, and if it is so, it is your duty to do justice with both of them without differentiating that a child is CCL and the another is child in need of care and protection. Now over to Monika.
Keeping in view the provisions of the Juvenile Justice, Care and Protection of Children Act 2015, the offences have been categorized in three categories: petty offences, serious offences, and heinous offences. Section 2, subsection 45 describes the petty offences, which includes offences for which the maximum punishment provided under IPC, now BNS, or any other law for the time being in force is up to 3 years. Serious offences have been described in Section 2, subsection 54, which includes the offences for which the punishment provided under IPC or BNS or any other law for time being in force is minimum imprisonment for a term more than 3 years and not exceeding 7 years, or maximum imprisonment for a term more than 7 years, but no minimum imprisonment or minimum imprisonment of less than 7 years is provided. Lastly, Section 2, subsection 33 describes heinous offences, including the offences for which the minimum imprisonment punishment under IPC, now BNS, or any other law for the time being in force is imprisonment for 7 years or more. Keeping in view the offences so committed by a CCL, the children are also categorized in two categories. The first category relates to the child who is below the age of 16 years on the date of commission of offence. And the second category relates to the child who has completed the age of 16 years or above the age of 16 years and has committed a heinous offence. In that case, where a CCL falling within the category of 16 to 18 years of age, having committed an offence which is a heinous offence, then a preliminary assessment has to be carried out by the board. Over to Mr. Amit Kumar Sharma ji.
I request all of you that while dealing with CCL, you have to follow the principles provided under section 3 of the Act. You cannot treat a CCL as an accused. These are principles of presumption of innocence, principle of dignity, principle of participation, principle of best interest, principle of family responsibility, safety, positive measures, non-waiver of rights, equality, right of privacy, repatriation, restoration, and fresh start. Now, I take you the procedure to be followed by a magistrate who has not been empowered under this Act to act as principal magistrate of Juvenile Justice Board. You can see Section 9 of the Act, which says that when a magistrate is of the opinion that the person alleged to have committed the offense is a child, he shall record his opinion and forward the child immediately along with record of such proceedings to the board having jurisdiction. Then comes subsection 2 of section 9, which says that in case a person claims before the court other than a board that he is a child, then the procedure provided thereunder is to be followed. The procedure provides that inquiry is to be made regarding age of such person. The procedure for conducting inquiry regarding determination of CCL shall be dealt by Monika later on. However, at this stage, I would like to tell you that it is the duty of principal magistrate to prepare roster so that at least one member of the board is always available when a CCL is apprehended and produced before. Many a times a question arises whether a member can grant bail or not. Of course, even a single member can grant bail. However, this order or decision is subject to ratification by the board. Then I take you people to section 12. I have been as children court and I have seen that while declining bail to a CCL, proper reasonings have not been given for one reason or the other. But gravity of offense is immaterial while you deal with bail application filed by a CCL. Bail can only be declined if the case is covered within the proviso provided under section 12 of the Act, and it says that there shall be reasonable ground that the release of the person shall bring him into association with any known criminal. Here I will take a pause because the word is known criminal. Sometimes the CCL is alleged to have committed an offense along with adult member. Then this is not sufficient for the proviso of section 12 of the Act. If the board is of the opinion that the release of CCL will bring into association with known criminal, then there has to be material in the form of investigating report submitted by the police or otherwise. A known criminal is the person who has either been convicted or facing the trial in some other case. Then second, expose the said person to moral, physical, or psychological danger. These are the three conditions separately. We have to keep in mind all these conditions separately. And the last one, if the board is of the opinion that release of CCL would defeat the end of justice, then of course the board has power to decline the bail application. But I request again that while passing the order, you have to take into consideration social investigation report submitted by the concerned police station so that the children court or the appellate court can evaluate the grounds on which the bail has been declined by you. Over to Monika.
Coming to the point of determination of age of a child or a juvenile, Section 94 of the Act provides where it is obvious to the committee or the board, based on the appearance of the person brought before it, that said person is a child, then the committee or the board shall record such observations stating the age of the child as nearly as may be and proceed with the inquiry as the case may be without waiting for further confirmation of age. Further, the section provides in case the committee or board has reasonable grounds for doubting juvenility, then it shall undertake the process of age determination, for which the board shall seek evidence by obtaining certain documents which have been mentioned in Section 94 itself, which consists of number 1, the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board if available. In case these documents are not available, then the birth certificate given by a corporation or municipal authority or panchayat, and in absence of all of these records, documents, then the age shall be determined by an ossification test or any other latest medical age determination test conducted as per the orders of the committee or board. As we discussed, if a child is under the age of 16 years, he has to be dealt with by the board in all the cases. But where the child falls within the bracket of 16 to 18 years and has committed heinous crime, then a preliminary assessment has to be conducted by the board within 3 months. Then either the board has to come to the conclusion that it has to be tried by the board, then board will continue. Otherwise, the board shall transfer the case to the children court if it comes to the conclusion that such a child has to be tried as an adult. Now it is important to discuss what kind of preliminary assessment has to be carried out with regard to the child in conflict with law. Section 15 of the Act provides for the same. We will also discuss the rulings of Honorable Supreme Court of India, giving the guidelines on this point. Under the existing framework, as I disclosed to you, a child between the age of 16 to 18 years, having committed an offense which is heinous in nature, may be transferred to be tried as an adult to the court, which is a children court. The decision has to be made by the board on the basis of the preliminary assessment. Now, for the purpose of making this assessment, the board can always take the assistance of psychosocial workers, psychologists, and other experts if it deems fit so. If we see the wording of the Act itself, it provides that the board may take the assistance. So there had been an interpretation by Honorable Supreme Court of India, whereby it has been observed that this word may has to be read as shall, and the board must go through the reports or take assistance of the psychosocial workers and psychologists or any other expert. So let us see what are the testing anvils of Section 15. First of all, what should be the nature of the offense to fulfill the requirement? As I told you, the nature of the offense must be as described under Section 2, subsection 33, that is heinous offense, which is punishable with imprisonment for 7 years or more. How it is to be carried out? This is Section 15 and Rule 10A of the Juvenile Justice, Care and Protection of Children, Model Rules 2016. And there is a timeline given under the Act that this assessment has to be carried out by the board within a period of 3 months. While making this assessment, the child has to be presumed to be innocent unless proven otherwise. For the purpose of conducting it, take the assistance of psychologist, psychosocial worker, or other experts. The preliminary assessment into heinous offences conducted by the board, Rule 10A of the Model Rules 2016, which provides the same thing, taking the assistance of the experts in order to ascertain what. There are three things which have to be seen by the board for the purpose of conducting the preliminary assessment as provided under Section 15. What are these three things? Firstly, the child's mental and physical capacity to conduct the alleged offense. Secondly, child's ability to understand the consequences of the offense. Thirdly, the circumstances under which the child allegedly committed the offense. For this, the board may always take into consideration the social investigation report, which is a report consisting about the detailed information pertaining to the circumstances of the child, situation of the child on economic, social, psychosocial, and other relevant factors. Social background report consisting of the background of the child prepared by the child welfare police officer. Preliminary assessment report consisting of the circumstances of apprehending the child and the offense alleged to have been committed by him. Statement of the witnesses and other documents which were prepared during investigation. Now the question that has risen before Honorable Supreme Court of India was whether it is mandatory to look into these kind of reports of the experts. This was answered by Honorable Apex Court in Varun Chandra versus Master Bolu in 2022 by saying that the word may, which is used in Section 15, is mandatory for taking the assistance of the psychologists, taking assistance by way of the reports of these experts who can ascertain their mental level of the child in conflict with law. They say, looking into the purpose of Act of 2015 and its legislative intent, particularly to ensure protection of best interest of the child, the expression may, which is used in 15, and the requirement of taking assistance of experienced psychologists, psychosocial workers, or other experts would operate as mandatory, unless, however, the Honorable Supreme Court says, unless the board itself comprises of at least one member who is practicing professional with a degree of child psychology or child psychiatry. Over to Shri Amit Kumar Sharma ji.
Thank you, Monika ji. Monika ji has given you a deep insight regarding preliminary assessment to be made by the board as per Section 15 of the Act. Here, I would like to add one point that it is the duty of the board to assess mental age and not biological age. You are aware of the biological age of CCL, but many times you determine the preliminary assessment on the basis of biological age, which is incorrect, and as per the ratio of law laid down by Honorable Supreme Court in various judgments. One has been cited now by Monika ji. Secondly, if you see Section 15, it says that the board shall conduct a preliminary assessment. It is the duty of the board to conduct preliminary assessment when the offense is heinous and biological age of CCL is above 16 years. But passing of order is not mandatory. If you consider that the offense was committed by CCL out of his mental incapacity, then the inquiry or the case is to be tried by the board, and such CCL may not be forwarded to the children court, because it is your duty to do justice with a child who has incapacity or incomplete faculty to understand the consequences of his commission and omission. Now, as per section 12, bail is to be granted to CCL, notwithstanding the gravity of offence. But once you have granted bail to a CCL, but he is unable to fulfill the conditions of bail within 7 days, then it is the duty of in charge of observation home or otherwise to produce such child before you for passing modification order. You can always ask the CCL or his guardian and parents the difficulties faced by in furnishing bail bonds, and you can accordingly modify the bail, because CCL is to be dealt as if he has not committed any offense. Now, section 14 of the Act says that if the petty offense is committed by CCL, then the proceedings is to be completed within 4 months, extendable by 2 months, but in no case beyond 6 months. After 6 months, the proceedings shall stand terminated. The mandate of section 14, subsection 4 is that the proceedings shall stand terminated. Secondly, I request all of principal magistrates of Juvenile Justice Board to try the CCL alleged to have committed a petty offense as summary proceedings, whereas the inquiry of serious offense is to be conducted as conducted in summons case. Once a CCL once inquiry is culminated by holding the CCL guilty, then you are supposed to pass disposition orders as per section 18 of the Act. The order is to be passed keeping in view the social background of the child and other factors. That's all. Something else. I'll just discuss more topics. Over to Monika ji.
Keeping in view what is the procedure in relation to child in conflict with law, first of all, as per Rule 8 of the Model Rules 2016, no FIR shall be registered except where heinous offence is alleged to have been committed by the child, or where such offence is alleged to have been committed jointly with adults. In rest all the matters, the SJPU, Special Juvenile Protection Unit, or the Child Welfare Police Officer shall record the information regarding the offence alleged to have been committed by the child in general diary, followed by a social background report of the child and the circumstances under which the child has been apprehended, and shall forward it to the board for first hearing. But there is also a proviso which says that the power to apprehend shall only be exercised with regard to heinous offences unless it is in the best interest of the child. For all the cases involving petty and serious, and cases where apprehending the child is not necessary in the interest of child, the SJPU shall forward the information to the board itself. It further says there are certain few things where a child alleged to be in conflict with law is apprehended. Then what is the duty of the police officer? He has to immediately inform the parents, guardian, probation officer, and the child welfare officer. Further, the police officer is not to send the child to the police locker. is not to handcuff the child, has to inform the child promptly about the charges against him, is not to compel the child to confess the guilt, not to ask the child to sign any statement, and has to give information to the DLSA for providing free legal services to the child. And as you all know, the child has to be brought before the board once he is apprehended within a period of 24 hours. This is Rule 9 of the model rules. And then the board may pass any order sending the child to an observation home or the place of safety or fit facility. In case the board is not sitting, the child alleged to be in conflict with law shall be produced before a single member of the board as per section 7 subsection 2. There is another circumstance where in case the child alleged to be in conflict with law cannot be produced before the board or even the single member of the board due to child being apprehended during odd hours or distance, then the child shall be kept by the child welfare police officer in the observation home in accordance with Rule 69D of Model Rules of 2016. Over to Shri Amit Kumar Sharma ji.
Last but not the least, sometimes a question is asked. Suppose the board has granted bail to a CCL, but afterwards he does not appear before the board. Then what is the procedure to be followed? In this regard, you can see section 26 of the Act. Any police officer, here the word is any police officer, may take charge of the CCL who has run away from a special home or observation home or place of safety, or from the care of a person or institution whom the child was placed under this Act. This is the last resort, and thereafter you cannot take any action against such CCL as has been provided in subsection 4 of section 26. No additional proceedings shall be instituted in respect of such child unless and until the child is produced before you. You cannot declare him proclaimed person or proclaimed offender, nothing else, but the file is to be consigned to record room. That's all. Miss Monika wants to add something more in this point. Over to Monika.
Talking about the custody of the juvenile when he is in custody, where he has to be sent, what kind of homes have been provided by the Juvenile Act. The types of homes are observation home, which are established as per the provision of section 47, which are meant for the child in conflict with law. During dependency of the inquiry, the child is sent there. Special homes, which are established as per the provision of section 47, where after the board concluded that the juvenile has committed the offense, is sent and a dispositional order is passed against the juvenile, CCL. Then place of safety, which is established under section 49 of the Act, in which CCL between the age group of 16 to 18 having committed heinous offense or above 18 are kept. Fit place, which is established under section 51 of the Act, which are sometimes the de-addiction centers as well. That's all.
Last point I would like to add. Suppose an inquiry is being conducted by a court regarding age of CCL or age of any person. Then during the course of inquiry, such person is not to be sent to jail. Such person is to be kept in place of safety as has been provided under section 49 of the Act.
That's all.
Thank you very much. If you have any query or question, you can write us. We will try to answer it to best of our knowledge and capabilities.
We are waiting for the queries from all the officers who are attending the webinar. I ये
क्यों आ गया है?
my children. So we have one query. If an accused is declared as CCL by court and forwarded to board in a heinous offense case, and by that time he has already attained the age of 20 years or plus, then preliminary assessment is still required to be done. If yes, then how it will be practically done, as the existing mental capacity of CCL is way more than of major.
Of course, preliminary inquiry is to be conducted because as per mandate and provision of JJ Act, such person is to be taken as child on the date of commission of the offense and not from the date of determination of his age. Second query, if yes, then how it can be practically done? You are right, there could be practical difficulty in concluding or arriving at just conclusions, because when the child is subjected to any observation of psychologist or psychosocial worker, then his mental faculty will be different as when he committed the offense. But we have to conduct such preliminary objections with all possible supports and thereafter conclude whether the person is fit to be tried by the board or tried an adult by the children court.
These were the observations given by even Honorable Supreme Court of India.
Any other query?
Officers, we are waiting for you all to raise any query. If officers are not able to raise any query right now at this point of time, you are always welcome to put a query by way of an email to the academy. So since we do not have any other query by now, so can we close the session, sir?
Thank you very much.
We are able to get another queries. First query is, in absence of principal magistrate, the board members can decide the bail ? This question has already been answered by Mr. Amit Kumarji.
Yes, the board member can decide the bail application, but subject to ratification when the board takes the sitting on the next time, as has been provided under the rules. Second query, if CCL is absent, what is the procedure to be followed? We have just stated you have to follow section 26 of the Act, but in no case the juvenile, in no case CCL can be declared as proclaimed offender.
How to deal in case of default bail for juvenile? Who all can apply for bail apart from CCL parents?
Default bail is a right given to CCL, but being a minor person, he cannot exercise this right. His guardian or parent can always exercise this right, but it is the duty of the board to intimate the CCL as well as his parents and guardian about right of default bail to CCL. Next query, can a duty magistrate deal with bail of JJB?
Can a duty magistrate deal with the bail of JJB? As it has been already discussed and told by Shri Amit Kumar Sharma ji, that a principal magistrate has always to prepare a duty roster pertaining to the member of the board who shall always be present at the station If the principal magistrate himself is not available, then the bail shall be dealt by the board, not by the duty magistrate.
The roster is to be prepared by the principal magistrate of Juvenile Justice Board, and it is the duty of at least one member to remain present at the station. And if, suppose for example, neither the principal magistrate or any member is present, then the juvenile is to be kept in the observation home by the concerned police station, but he cannot be produced before any duty magistrate. We have already answered this query. Any other query?
The queries which we have received have been answered. If there is any other query, we are waiting for another 2 minutes. So, sir, should we declare the session closed?
Session is closed. Thank you very much.
Thank you, officers. Thank you.